Okay, I do appreciate being here this morning. I know you're coming in saying, oh my God, 75 minutes to 90 minutes of the law. This is going to be boring. It can be if you want it to be, or it can be informational if you let it be. I've been prosecuting. Come August, I will have served as a prosecutor for 30 years. Been the elected county attorney in Ellis County 22 years of that stretch. I've also had the privilege of serving on the Kansas Sentencing Commission for 8 years, appointed by 2 different governors, and I got to serve on the Recodification Commission that rewrote the laws in Kansas for 3 years. These past 8 years, I've also served as an appointed Deputy Attorney General by Attorney General Derek Schmidt. I prosecute sexual violent predator crimes, and I'm on the committee that reviews sexual violent predator prosecution in the state of Kansas. So I've done this quite a while. I've got quite a bit of experience. It is warm up here, so I'm going to shed my jacket. In my spare time, when I'm not prosecuting, I've been an assistant scoutmaster for 10 years, and I also teach an 8th grade confirmation class. I'm in my 14th year of doing that. So I can talk to you about a various array of subjects. We're going to talk about legality, not morality. And there is a difference sometimes between what's legal and what's moral. Okay, so today we're going to talk about what's legal and what's illegal. Okay, we're going to focus on social media crimes, crimes that can be committed with your cell phones, your smartphones, computers, that kind of stuff. Okay, if you have questions, raise your hand and we'll ask the question. As I warn all my kids in confirmation class, if you ask a serious question, you'll get a serious answer. Okay, I'm going to talk about some things that may be a little uncomfortable to you. We're going to use phrases that may be uncomfortable for you. Well, you're becoming young adults, and my goal here is to give you a fair heads up on how you can be breaking the law. And I like to do this in the Hayes schools, Ellis, Victoria, Hayes, to give the kids a fair heads up so that if they do break the law and I have to prosecute them, I know they had fair warning. And so I don't feel near as bad when I have to prosecute them. Okay, so if you have questions, ask. First off, how old do you have to be to drink alcohol legally? 21. Is there an exception to that? Who says yes? Raise your hand. Who says no? How's come no hands are going up? Okay, what's the exception to being 21? Okay, if you're with your adult parent, it has to be your parent or your legal guardian, they can allow you to consume cereal malt beverage, which is beer, basically. Okay, 3-2 beer, but really any beer. Reality, parents can allow you to drink pretty much any alcohol because most prosecutors aren't going to file as long as your parent is there supervising you. But your parent has to be there supervising you. Every year we have Oktoberfest in Hayes. Every year we end up arresting college kids who have a note from their parents. Some of them even have that notarized, saying it's okay for my child to drink at Oktoberfest. No, not if the parent's not there supervising. So your parent has got to be there supervising you. Is it unlimited? Can your parent let you get drunk? No. Can your parents say, well, I'm going to let you go to a party that someone else is throwing, and it's okay for you to drink, but I'm not going to be there? No. That's called social hosting. If you supervise other kids drinking, that's social hosting. It's a minimum $1,000 fine and up to a year in jail. Okay. How about if you furnish alcohol to someone else directly or indirectly? You're the one who arranges to purchase it, and you share it with your friends. That is distribution. That is furnishing alcohol to a minor. That's a minimum $300 fine and county jail up to 6 months. How about possession itself? Possession of alcohol by a minor or consumption by a minor, $200 minimum fine. By the time you add $158 court costs and a $60 probation fee and a $45 fee for the county sheriff, you're easily into $450, $500 for a beer. So think about that. Worse yet, if you want to go to the military and you have an alcohol minor in possession crime, they have to get a waiver from the Secretary of Defense to let you join the military just because you had a minor in possession. Okay. Scholarships and financial aid for college can be greatly affected by having a minor in possession or a marijuana possession. If you have any kind of drug possession crime, you're ineligible for federal aid. And college is expensive. You want to be eligible for federal aid. Okay, so you got to be 21 to drink unless you have parental supervision. And parents obviously can't get you drunk because that makes them endangering a child. But they can supervise you drinking. How about if you go out to a restaurant? Can your parents supervise you there? Yeah. But will the restaurant serve you? Probably not, because they don't know if that's really your parent. So they're probably not going to serve you. But they could. They could serve you beer with your parents supervising you. So if you're going to drink, you got to drink with your parents. That's the only legal way for you to drink till you're 21. How about use of tobacco? How old do you have to be to use tobacco? 18? Any exceptions to that? No, there's no exceptions. Parents cannot allow you to use tobacco products under 18. They can't allow you to drink, but they can't allow you to smoke. Why do you think that is? I have no idea. The only thing I can think of is the alcohol lobby was a lot stronger than the tobacco lobby when they got the laws passed. So alcohol lets your parents supervise your drinking, but tobacco, they can't. So you have to be 18 to have tobacco products. Or there's a $50 fine that goes with that. And by the time they throw in court costs, you're talking a couple $100. It makes it pretty expensive. How old do you have to be to engage in any kind of consensual sexual activity? 16? Who says 16? Who says you have to be older than that? Who says you can be younger than that? Okay, the age is 16 to have any kind of sexual contact. Is there an exception? And don't talk about direct parental supervision. Okay, that's just wrong on a lot of levels. And you laugh about that, but I've had to prosecute cases where parents have supervised their kids having sex. Okay? So you have to be 16 to consent to any sexual activity. The only exception to that is if you're married. Parents can still, under certain circumstances, allow you to get married under the age of 16, but that's extremely rare. But short of marriage, you have to be 16 to engage in any sexual activity. And believe me, I'm not up here telling you once you're 16, it's okay to become sexually active, because it's not. But that's the difference between morality and legality. The law says at 16 you can consent. Morally, you really ought to strongly consider waiting till marriage for a lot of reasons. One, it's pretty easy to accuse someone of a sexual crime. I've got a son who's a junior at KU. In fact, he's driving back there now because he's also a cheerleader at KU. He's on the cheer squad. And they got a ball game tonight. So he's driving back to KU. But I had the same speech with my son and daughter when they were 16 and told them, look, at 16 you can consent to sex. I hope you don't. I hope you wait till you're married because you're really not mature enough at 16, but you can. But I encourage both of them that if you're going to have any sexual activity, I want you to write up an agreement with the person you're going to have sexual activity with. Both of you sign it, both of you date it, and get it notarized so that you have proof that the person you're going to engage in sexual activity is consenting. And my daughter looked at me and said, "Don't you think that's going to kill the mood?" And I said, "God, I hope so." But the reality is, it is very easy to accuse someone of inappropriate sexual behavior because consent comes down to the two people there. And people change their mind and then they regret. And the next day they regret, and suddenly what was consensual is now claimed to not be consensual. So you've really got to protect yourself in this day and age. So I would give you the same advice, just like my kids. If you're going to have sexual activity, write it down, what you're agreeing to do with each other, sign it, go get it notarized, and protect yourself. And hopefully if you take that step, you'll think better of it. But you have to be 16 years of age to engage in any sexual activity. And when we say that, what do we mean? What is sexual activity? Come on, you've all had this in biology, you've all had this. What is sexual intercourse? Sexual intercourse is any penetration of the female sex organ, no matter how slight. So if the vagina is penetrated, whether it be a penis, whether it be a finger, whether it be an object, that is sexual intercourse. So any penetration under age 16 is illegal. A lot of times we find out about this when a girl shows up at her doctor and or the hospital to get checked because she's pregnant or thinks she's pregnant. Well, they're mandated reporters of child abuse, just like teachers are mandated reporters of child abuse. And so they do report it, and then we have to investigate it. And then we have to decide what happened. But the bottom line is you cannot consent under the age of 16. And any penetration equals sexual intercourse. But there's other levels of crime. What is sodomy? Sodomy is the penetration of the anus by any object, or what you call oral sex. Any penetration of the vagina by a tongue or putting a penis in your mouth. That is sodomy. That's also a crime. Those are all serious felonies that will land you in prison. And once you're over 14 years of age, there's a presumption to bump you up to adult status if the crime is serious. And if they bump you to adult status, you're looking at prison. Okay? You're looking at a prison sentence. So this gets real serious real fast. What's sexual battery? Sexual battery is any touching of the person without their consent. It's done in a rude, insulting, or angry manner. You touch a body part that is normally covered by underwear without the person's consent, that's a sexual battery. It's a Class A misdemeanor. You can go to jail up to a year. Worse yet, you have to register as a sex offender for a minimum of 15 years. So what did you learn in kindergarten? Keep your hands to yourself. Okay, it's pretty simple. It's pretty simple. Keep your hands to yourself. But it can be as simple as you're walking down the hall and you slap someone on the butt. That can be a sexual battery. You can end up with an A misdemeanor and you can end up registering as a sex offender for 15 years. Okay, so be careful. Be careful with that. Questions? Alcohol? Sex? Tobacco? Let's talk about crimes you can commit with social media, i.e. using your computers or phones. The first one is sexual exploitation of a child. That is what you commonly call child pornography or kiddie porn. Okay? If you have pictures of someone in a state of undress and they are under 18 years of age, you're in possession of kiddie porn. That's a level 5 felony in Kansas. That's a presumed prison offense in Kansas. And you all smile and say, oh, that doesn't happen. Yeah, that happens way too much. We know we get computers back in the school district that we loan out. We randomly check them, and generally at least 40%, usually 50% of them have had pornography on them. Kids are looking up porn. You guys are living in a wonderful age with technology. You've got the whole world at your fingertips. The internet puts the whole world at your disposal, which is good and bad, because it not only gives you access to everything good in the world, it gives you access to everything bad in the world. And you're the ones who make the decision how you're going to utilize it. Whether you're going to utilize it for good or whether you're going to utilize it for bad. Whether you're going to look at appropriate sites or whether you're going to take time to go to inappropriate sites. And what most kids your age don't know is when you go somewhere on your computer, once you've been to that site, even if you delete it, law enforcement can still go back and see everywhere you've been on a computer. So even though you go to the site, you look at some porn, then you delete it, law enforcement can capture that and tell you exactly where you've been and look at what you've been looking at. Okay? So think about that. Sexual exploitation also includes persuading, inducing, enticing, or coercing a child under 18 to engage in sexually explicit conduct. What is sexually explicit conduct? That is actual or simulated exhibition in the nude. Nude means any state of undress in which human genitals, pubic region, buttocks, or the female breast is less than completely or opaquely covered. I.e., if you can see body parts that are normally covered up by underwear, that is nude. If you possess photos of nude body parts and the person and the body parts are pictures taken of a person under 18 years of age, that's possession of child pornography. And that's a level 5 felony. Unlawful possession of a visual depiction of a child, which is a very long term for talking about high school kids having pictures of each other or having pictures of nude people. Okay? If you possess a visual depiction of a child ages 12 through 15, if they're under 12, it's just sexual exploitation. It's just kiddie porn, plain and simple. But if you possess pictures of a kid aged 12 through 15, and you are less than 19 years of age, i.e. high school, and the child is in a state of nudity, and you receive the depiction directly from the person, someone takes a picture of their body part and sends it to you, if you did not solicit, coerce, or request the photo, and you did not transmit it to anyone else, and you, in good faith, immediately deleted the picture and destroyed the picture, that's a Class B misdemeanor. If you kept the photo, it becomes a felony. Unlawful transmission of depiction of a child. In Kansas, that's a level 7 through level 10 felony depending on the circumstances. But if you receive a picture of someone and they're underage, they're under 18, and it's showing naked body parts, and you pass that on to somebody else, or you show it to somebody else, y'all huddle around in the locker room and say, hey, look at so-and-so, look what she sent me. And you're distributing, looking at those photos. That's a felony offense. If you do it with intent to harass, embarrass, intimidate, or defame the other person, or cause emotional, psychological, or harm, physical harm, then it becomes aggravated unlawful transmission of a visual depiction of a child. And that's a more serious level felony. Please value yourself. Don't be taking pictures of yourself and sending them on to other people. Don't be asking. If you ask someone to send you pictures of them, that's a felony offense. If you solicit them to send you pictures, that's a felony offense. And if your folks find it, or law enforcement ends up searching your phone for any reason and they find this, you're going to be looking at a felony offense for having that. So please value yourselves. Don't be taking pictures of yourself and sending them to other people. And don't be asking other people to do that. Because if they receive it, if you take a picture of yourself and you send it to somebody and it's on their phone and they've got it and they didn't immediately delete it, they just left it on their phone, you've caused them to commit a B misdemeanor. If they solicited it, asked you for it, that's a felony offense. Okay? So be careful with that. Value yourselves. Value yourselves. For those teachers who have outlines, we're now on to page 2, breach of privacy. Breach of privacy. If you install or use any device or equipment to intercept communication from another person without their permission, or if you conceal something to take photographs or images, or secretly videotape, film, or photograph a person, and you end up getting them in a state of undress, nudity, as we talked about, body parts that normally are covered by underwear are now uncovered. And this can be as simple as putting your phone down by a toilet in the bathroom and leaving it run, setting it up in the locker room and letting it run. If you capture pictures of someone without their consent or knowledge, that's an invasion of privacy. If you disseminate that to another person, i.e. show it to someone or send it to someone, that's a level 5 felony, presumptive prison. Okay? If you do it for the purpose of viewing the body or the undergarments of the person without their consent, that's also a felony offense. So in this situation, you put up your camera, you put up a phone or something in a locker room or a bathroom and get pictures of them in their underwear without their consent, that's a felony offense. It doesn't even have to be nudity, just their undergarments. Kansas now has what's called revenge posting. If you have photographs of a person, and this is for people 18 years of age or older, because remember, under 18, it's a felony to have those. But let's say you're 18 and you take pictures of each other and you disseminate them, which is legal. But you then revenge post. You take that picture and you send it to somebody else. And you do it under circumstances in which you do it to harass, threaten, or intimidate the person. Revenge posting is a level 8 felony in Kansas. So even if you have pictures of someone and it was legal, and then you later revenge post them, that's a felony in Kansas. This gets into areas of cyberbullying, basically. Okay? You can get into cyberbullying, where you can commit crimes without actually being in direct contact with the person. And I'm sure you've had classes about that, and I'm sure you've talked about cyberbullying. Okay? This is one example of that. Promoting obscenity. If you have pornography on your phone, that constitutes obscene material. And obscene material is defined as if an average person applying contemporary community standards finds the material patently offensive, or it represents depictions of the ultimate sex act, normal or perverted, actual or simulated, even if it's cartoons, including sexual intercourse or sodomy, or showing masturbation, excretory functions, people going to the bathroom, sadomasochistic abuse, or lewd exhibition of the genitals. That is promoting obscenity if you disseminate that. Sell it, give it, provide it, lend it, mail it, deliver it, transmit it, or in any way distribute that material. So if you've downloaded something that would be legal for you to have, but it's obscene material and you're disseminating it to other people, you could end up charged with promoting obscenity, which is a Class A misdemeanor on the first offense or a felony on the second offense. Electronic solicitation. If you use electronic means to solicit a child who's age 14 of years or older, but under the age of 16, i.e. if you're soliciting 14 or 15-year-olds to commit an unlawful sex act, and because they're under 16, all acts are unlawful. This includes inviting, persuading, or attempting to persuade the child to enter into any vehicle, building, room, or secluded place with the intent to commit the unlawful sex act upon them. That is electronic solicitation. That's a level 3 person felony. That's presumed prison. It includes emails, chat rooms, conversations, instant messaging, any electronic solicitation of the child. So if you're electronically soliciting someone to engage in an illegal sex act, you could end up with a level 3 felony for soliciting them electronically. Yes, in the back.
So you're talking about these level 3 felonies and everything. Could you put that in years?
Yeah, the most severe is a level 1, and even if with no history, you're talking about 13 years of prison. A level 3, you're talking about 6 years of prison time. A level 5, you're talking about 2.5 years of prison time, where you go to prison. That's with no history. If you have history, that time can double and quadruple. An A misdemeanor is up to a $2,500 fine and up to a year in jail. A B is up to a $1,000 fine and up to 6 months in jail, and a Class C is up to 30 days in jail and up to a $500 fine. And once you get into felonies, the judge can fine you as high as $100,000 for a level 7 through 10, $300,000 for a 4 through 6, and $500,000 for a 1 through 3. So it gets real serious real fast. We're on to page 3 of those of you who have the outline. Criminal threat. A criminal threat is any threat to commit violence communicated with the intent to terrorize another or cause the evacuation of the building. even if it's recklessly done, even if you did it as a joke. It's aggravated if there is any interruption of the facility, the place, or a lockdown results. This is where you send in like a bomb threat to the school. That would be a felony. That could be a level 5 felony, presumptive prison, if they end up locking down the school. But it also could end up with a level 9 felony for you if you're threatening somebody. You send a message to somebody over your phone threatening them, I'm going to beat you up, I'm going to do this or that, anything where you're threatening them, that's a criminal threat. And that's a felony offense if you use your electronic media to do that. Okay, so you can't threaten people over your phones. You shouldn't be threatening people anyway. But if you use electronic media to do it, you're looking at a felony. Okay, if you do it in person, you're looking at a felony. A criminal threat is a level 9 person felony. Don't be threatening people. How about criminal defamation? Do you know what defamation is? Criminal defamation is when you spread information about a person you know is false, and you do it maliciously. If you expose them to public hatred, contempt, or ridicule, or deprive them of public confidence or social acceptance, you're making fun of someone and you send it out, and you use your phone to send it out, and you're spreading gossip, and you're doing that to hurt someone, that's criminal defamation. It's a Class A misdemeanor, up to a year in jail, up to a $2,500 fine. If you do it orally, without your phone, it's slander. Okay? It's called slander. Now, what's interesting about these crimes is that most crimes in Kansas also have a civil aspect to it, so they can sue you civilly as well. So there's a criminal aspect and a civil aspect. Defamation, you lie about somebody, you print it over social media, put it out over social media, or slander if you're doing it orally, and you're doing it to harm someone. There's no gossip in your high school or your junior high, is there? None at all, right? A lot? Okay. If you do it to a financial, there's also a criminal false communication concerning financial. How about computer crimes? Can you commit crimes on the computer? Computer crimes themselves, if you without authorization access, damage, modify, alter, destroy, copy, or take possession of a computer or computer system without the permission of the person who owns it, and you exceed the limits of authorization for that computer, that is a computer crime. That can be a level 8 felony, level 5 if you do damage over $100,000. Computer trespassing, if you intentionally and without authorization access or attempt to access a computer, computer system, or a computer network, software, program, documentation, data, or property, or disclose a computer password without permission, which is the disclosure of the number, code, password, or other means to access a computer or computer network. That is trespassing on a computer, okay? Which is a crime in Kansas. How many of you have access to someone's PIN number? How many of you know that you can use electronic cards to access money? Yeah, if you have someone's PIN number and you disclose that PIN number without their permission, and they suffer a financial loss because of it, you can be charged with a crime for disclosing the PIN number. If you have someone's access code onto their smartphone and they've got personal information on there, and you pass that on to other people, and other people get in on their smartphone, which constitutes a computer, and gains access to their phone without their permission, and you've passed on that number, you've committed a crime. Okay? You guys have all kinds of landmines that we didn't have when I was your age. We didn't have to worry about any of this. If we wanted information, you went to the library and looked it up. You know, you guys have the world at your fingertips. Good and bad. Good and bad. On to page 4 of the outline. Piracy of recordings. Back in the day, that was making bootleg copies of 8-tracks or CDs or albums and distributing them on to people. Well, now that's still a crime, but you also have all the computer aspect of it. If you record copyrighted material and pass it on without permission. And Kansas has a financial component to that. But if you're passing on copyrighted material without permission, you can end up in violation of what's called piracy of a recording. So you have to be careful of copyrighted materials. You have to be careful that you buy a computer program and then just distributing it to other people without permission, because those are licensed products. And if you're violating the license, you can be committing a crime. Identity theft. If you obtain, possess, transmit, use, or attempt to obtain, possess, transfer, or use one or more identification documents or personal identification numbers of another person, which we were talking about just a little bit ago. That's identity theft. So you're passing on information that someone has that's private to them. Passwords, PIN numbers. That's identity theft. If that gets used by someone to their detriment, you're part of that crime. How about marijuana? Is it a crime in Kansas to have marijuana? Yeah, it is. Is there an exception to that? Any exception? There's no parental supervision aspect to it. Kansas doesn't have medical marijuana. Bottom line, possessing any marijuana in Kansas is illegal. And the first offense is a Class B, second is a Class A, and third possession becomes a felony offense. So you can't legally possess marijuana in Kansas. But here's something most people your age don't know. If you unlawfully arrange a sale or purchase of a controlled substance, including marijuana, using your communication facility, i.e. your phones, that's a level 8 felony. So you're thinking, well, I'll take a chance. I'll go ahead and possess some marijuana. It's a Class B misdemeanor. But if you're arranging getting the marijuana using your phone, you're committing a felony. And so a lot of times with law enforcement, it's not so much the marijuana as the use of the communication facility to obtain the marijuana, because now you've committed a felony offense. The one where you really get burned using your social media is conspiracy to commit a crime. Conspiracy to commit a crime. What's that mean, conspiracy? What's a conspiracy? A conspiracy is two or more people agreeing to do something, particularly if it's illegal. You conspire with other people to do something. Okay? The conspiracy itself is a crime. So if you conspire with another person via internet or your phone, Snapchat, social media, whatever, you conspire with another person to commit a crime, you're guilty of that crime. So for example, someone decides they're going to have a party. They're going to have alcohol at the party. They start spreading out on their phone and sending invitations to other people. Hey, we're going to have a party at so-and-so's place and there's going to be alcohol. You've just entered into conspiracy for the underage possession of alcohol, the distribution of alcohol, and social hosting. So you've just committed a crime by using your phone to invite underage people to an alcohol party. So it's very easy to get tripped up with that. If you conspire to do a misdemeanor, it's a misdemeanor offense. If you conspire to do a felony, it's a felony offense. So you can be conspiring with someone to obtain some marijuana, and the person's got 2 prior convictions for possession of marijuana, so now it's a felony possession of marijuana. By conspiring with them, you're committing the same felony. And everybody in the conspiracy is responsible for all the crimes committed during the conspiracy. Okay? So this thing can get really crazy out of hand. And the problem is, you're looking at financial aid, you're looking at scholarships. This can really bite you when you go to apply for college, trade school, after high school. How about false impersonation? If you represent yourself to be a public officer or public employee or a person licensed to practice any profession or vocation in which a license is required, and you pass yourself off as that person, that is a crime. That's a Class B misdemeanor, to falsely impersonate someone. Okay. I had a case here just year before last. A young lady was telling her boyfriend she was pregnant, and he didn't believe her, so she falsified a letter from Hayes Medical Center, put together the letter on some letterhead she was able to take and morph, and signed her doctor's name and gave it to the boyfriend saying she was pregnant, trying to get him to get her to marry her. That's a crime. You know, that's false impersonation of that person. You know, teachers are licensed. You use your phone and pretend to be a teacher who's a licensed person in Kansas to pull a gag by passing on information saying, I'm the teacher or I'm the principal, and pass this information. You have committed false impersonation, which is an offense. These are things you learned in kindergarten. You don't lie, you keep your hands to yourself. This is pretty simple stuff. But you throw the social media into it and it can get complicated in a hurry. And you can end up committing crimes you're not even aware of. How about gambling? Can you legally gamble in Kansas? Who says yes? How can you legally gamble in Kansas? Obviously, you can go buy scratch tickets and things of that nature, which is basically gambling. Okay. You can do split the pots. That's gambling. But if you do it right, it's legal in Kansas. But what about using your phone to place bets? No, that's a crime. That's a crime in Kansas. So if you're making bets or participating in a lottery that's not legal and using your phone to do it, you're committing a crime. So you can very easily slip into some of these things. You can very easily slip into some of these crimes. Okay? So, for example, and this isn't necessarily a social crime, this is just reality of person. Let's just talk about basic crimes that you can fall into at your age. You go to a party, you didn't know there was going to be alcohol, but you get there and lo and behold, there is alcohol. And your friend is there and your friend's been drinking. And so you give your friend a ride home. And your friend has a can of beer in their hand as you're giving them a ride home. Problem? Who thinks that's a problem? Yeah, that's transporting an open container. Okay. Who gets in trouble for that? The guy with the beer, because they're transporting an open container, but also the driver, because the driver is responsible for the activity in the car that they're aware of. So they write up both the passenger and the driver for that open container. Okay? An open container conviction in Kansas will double your insurance. That will double your insurance. And if you ask your parents how much it costs to insure you to drive at your age, if you double that, most parents are going to say, no, you don't get insurance, you're going to be walking. Okay? What's the legal limit for driving as far as alcohol consumption? It's 0.08. But what if you're under the age of 21? It's under the age of 21, it's 0.02, which is basically a beer or a mixed drink. And then you can lose your license for a year. Okay, so you can't drink and drive. You can't drink and drive. If you were to get a DUI, your insurance quadruples. It goes up 4 times what it currently is. Again, this is one of those moments. Ask your parents if they're going to continue to pay insurance for you if it's 4 times the normal rate. Most of them aren't. Most of them are going to say, get a bicycle or walk. Okay? Because your insurance goes up 4 times the normal rate if you get a DUI. Let's go back to that car situation. Okay. You guys are sitting in class and it's a Friday afternoon and you're talking about going to a party and there's going to be alcohol at the party. So you come up with a designated driver. And someone agrees to be the designated driver. So they pick the other people up, take them to the party, the other people drink, they drop them home from the party. Any problems in that scenario? What are the problems you see? What are the problems? Okay, you knew there was going to be alcohol at the party and you knew there was going to be underage drinking. Is that legal? No, that's a crime. So when you've agreed to be the designated driver, what have you done? I can't hear you.
Became a part of it.
Yeah, you just conspired with that person that they're going to consume alcohol underage and you're going to give them a safe ride there and back. Now, morality tells me that's a great thing, and you should do that, and you should take care of your friends. But under the law, if you conspire ahead of time to help them break the law, you've broken the law with them. They get tagged for underage consumption or possession. So do you if you're the designated driver and you agreed ahead of time to do this. So sometimes it can come back and bite you, even though you're doing the right thing, the good thing. The right thing being the designated driver, except you're encouraging the other people to break the law. And you're aiding and abetting them to break the law. And if you aid and abet somebody, help them to break the law, you've committed the same crime they've committed. So under a conspiracy or under aiding and abetting, you can get tagged for that. What's that? Yeah, I didn't see who said that. Yeah, someone in the back said, it's like driving the getaway car at a robbery. Yeah, if you're the wheelman, if you're the driver, somebody runs in and robs the convenience store, jumps in the car, and you drive away, you're just as responsible for the robbery as the person who went in. You can be just as responsible if you're the one driving, if you conspired ahead of time to do that. Okay, because you entered into a conspiracy to break the law, you aided and abetting the breaking of the law. Okay. How about this scenario? You go to a party, you didn't know there was going to be drinking, there ends up being drinking, and your friend gets really wasted, passing out drunk, sloppy drunk, passing out. One, is that a problem? I mean, obviously the underage consumption is a problem, but if somebody is getting to the point where they're passing out from alcohol, they're suffering from alcohol poisoning. And that's a very dangerous situation. In Kansas, we average about 10 kids a year dying from alcohol poisoning. Okay? This is a medical emergency when somebody has consumed alcohol and they're passing out. What do you do? What do you do when you're at this party and someone's passing out? What's that? Yeah, call an ambulance, get some help. Call their parents, get some help. Call the police, get some help. Are you going to be in trouble under the law if you do that? No, you're not. You're not. Anyone who is seeking aid for a person who is undergoing a medical emergency, and pass out drunk is a medical emergency, folks. There's no crime involved with that. Okay. Kansas has rewritten its law recently that even if you knew there was going to be alcohol at the party, even if you're part of the party, if you're at a party and somebody needs help because they're very drunk and you access help for them, you're not going to be held responsible legally for any crime having distributed alcohol or possessed alcohol because you are accessing medical care for that person. Sounds kind of contradictory, doesn't it? But Kansas is trying to stop underage kids dying from alcohol poisoning because other kids don't want to get in trouble, so they don't report. Law enforcement has very mixed emotions about this law because they're saying, well, wait a minute, you put together an alcohol party, that's wrong. You have the alcohol party, that's wrong. We get called to the alcohol party. The person who calls us can't be prosecuted for any alcohol crime because they're accessing help for another person. That's the reality of the law in Kansas. If you're accessing help for someone who needs help, they cannot prosecute you for an alcohol violation. We want to encourage you, if somebody is drinking heavily and they hit that point where they're incoherent, that's a medical emergency, and you need to access that person some medical care. Call them, call the ambulance, call their parents, call the police, get them some help, and you won't be in trouble. So questions over stuff we've covered? Yes?
On that topic where you have all the ambulance and you have somebody who's not intoxicated on that level, we need to know how much they have to drink, if they use any drugs. And it's not because we're going to try to prosecute for that. It's because that's the only way to help them. So if, say you have marijuana or any alcohol whatsoever, we need to know exactly how much you consume so we can get it.
Were you able to hear him? He was saying, from a medical point of view, they need to know if they're going to provide help, how much the person consumed, whether it was alcohol, whether it was alcohol and marijuana, alcohol and any other drug. They need to know if they're going to help that person. Okay? But under the law, as long as you're making a good faith attempt to access medical care for the person, you're not going to be prosecuted for any of those crimes. Because we value human life. And it's more important to get help than to worry about the alcohol violation. Yes?
How long does an MIP stay on your record?
An MIP will stay on your record for 7 years, and then it decays off. You can expunge it after a 3-year period. You can go through a legal process of expungement and take it off that way. But if you don't go through the expungement process, the erasing process, it stays on for 7 years. So misdemeanors that you commit will stay on for 7 years. If you committed them as a juvenile, it's a 7-year decay process. If you commit it as an adult, it just stays on your record unless you expunge it. So if you're 18 and you get an MIP, it's just going to stay on your record unless you expunge it.
And that record can be seen by anyone?
Records are becoming more and more public record, yeah. Obviously the court documents are public records, but more and more people have access to the records, and more as, again, computers and the age of information, that information is readily available. So under some circumstances, you can obtain a person's record, but in this day and age of the internet, all you got to do is type the person's name in, and it will take you to everywhere something has been made public record with that name. Sometimes there's a fee to access that information, sometimes not. Well, like if your local newspaper publishes people who have been arrested, and they put that on the internet, it's there, and it's there forever. That's one thing people don't think about when, for example, they take those pictures of themselves in their underwear and send it to a boyfriend and send it out over social media. It's out there. And at 14 or 15, that may seem like a funny thing to do, a cool thing to do. But when you're 23 and you've just invested a lot of money for college, and now you're seeking employment, and they Google your name and stumble across a photo of you, 14, in your underwear, you think you're going to get hired? I mean, this can really hurt you. This can really hurt you. Yes. Yes.
If you call the ambulance for a friend that is drinking, but when everybody else in that party gets in trouble.
His question is, if you call the ambulance, how about the other people at the party? Yes, the other people at the party can get in trouble for consuming because they did not seek help for that person. One scenario we've discussed with the law enforcement is, what do you do if you're an officer and you come to the door, and as you're walking up, everybody starts yelling, we need help, this person needs help. It becomes very problematic for law enforcement. And I'm not suggesting you use that as a way to get out of it. What I'm telling you is don't drink in the first place. But if you have been drinking and you've got a friend at the party who needs medical assistance, get them help. You will not get in trouble for that. Other people at the party, they can get in trouble. They're underage drinking, they didn't get help for the person who's passed out. They didn't do the right thing on many levels, legal and moral. Yes?
Just wondered your comment about schools and employers and so on. Do they come to you for information how often? Or are you asked to reveal things, or is that just their personal service? How do they go about looking into those types of things and see what's on the record?
Normally they go to law enforcement or the court because they hold the public records. Prosecutors don't really hold public records in their office, but the record that the police make is a public record. Even on a juvenile offense, the front sheet is a public record. And then the court, obviously everything is a public record. Back when I was a child your age, anything we did in juvenile court was sealed, and it was not a public record. That is no longer the case. Now, juvenile proceedings, juvenile offense proceedings are public, open to the public, and those are public records. So back in our day, if we did something stupid and we ended up in juvenile court, nobody knew about it, and that was all sealed. Today, that's all open public record. So we're a lot harsher on juveniles than we used to be as far as juvenile offenders. Those are public records. And when you're filling out job applications or scholarship applications, you're asked to disclose that information, and they're going to check on it. They're going to check on it. And it could adversely affect you. What is your responsibility if you are to father a child? So guys, pay attention. If you father a child, what's your responsibility? Under the law, you are legally responsible for all the costs from conception until either 18 years of age or graduation of high school, whichever takes longer. And it's normally the graduation of high school. So if you think about this, if you have a baby born in September and they're graduating, you could be responsible from the time of conception till they graduate for 19 and a half years. You're legally responsible, financially responsible. And the latest U.S. News and World Report had the cost of raising a child, prenatal care through graduation of high school, is about $180,000. $180,000. Tack on college, you can add another $80,000 to that. So the cost of raising a child through college, national average, is $240,000. That's $250,000. So if you're not ready to commit $250,000 of your resources over the next 19 and a half years, or 22 years if they go to college, you better think twice before engaging in sexual activity. Because that's the cost to raise that child. And you're going to be held responsible for it. Because if a woman gets any kind of aid, she has to name a father. And the father will be pursued for the child support. So these are adult activities, and these have very adult ramifications to them. And you need to be prepared for those adult ramifications if you want to engage in this behavior. Questions? Other questions? Quiet group. Very quiet group. Because there's no drinking in Osborne County, right? And there's no drug abuse in Osborne County? Yes.
Another question about the sexual offender registry, and that's public knowledge.
Yeah, the offender registration is a public document. And even for, like I said, a sexual battery, that's a minimum of 15 years. Most felonies on first offense is a 25-year registration, and more serious felonies and or a second offense is a lifetime of registration.
There's no getting that off of your record.
No, there's no process under Kansas law right now to be removed from the registration. That is just part and parcel of the punishment, and it stays on there. And so, yeah, you see some situations, you know, like I said, a sexual battery, touch someone, they don't want to be touched, touch them where their underwear is, against their will, sexual battery, you could end up a registered sex offender for 15 years. Try getting a job. Try getting a scholarship as a registered sex offender.
Try getting an apartment.
Try getting an apartment as a registered sex offender. And there's no process right now by which that comes off. Okay. We talked about battery in the context of a sexual battery, but we also just a battery itself. Any touching of another person done in a rude, insulting, or angry manner is a battery. That's a Class B misdemeanor. If you stand and intimidate somebody and cause them to fear for their safety, that would be a threat, an assault under Kansas law. An assault is a Class C misdemeanor. Up to 30 days in jail, up to a $500 fine. If you batter them, if you touch them without permission in a rude, insulting, or angry manner, that's a battery. That's a Class B on the first offense. Up to a $1,000 fine, up to 6 months in county jail. And the part that most kids don't figure out is those crimes are crimes whether you're inside the schoolhouse or outside the schoolhouse. A battery down at the park is a battery. A battery in the school is a battery. There's no exception saying unless you're on school property. So if you batter someone in school, that's still a crime. If you assault someone in school, threaten them, that's a crime. And there's no exception saying, well, they're in school. There is no exception under the law for being at school. Those are still crimes. Teachers are mandated reporters of abuse. So if you're a child and somebody is abusing you, whether that be a parent, aunt, uncle, older brother, sibling, friend, anybody abusing you, if you talk to a teacher about that, they will help you report that. They are mandated reporters. Okay, nobody should suffer abuse. Nobody should suffer a situation where somebody is doing either physical harm to them or sexual or psychological harm to them. If you're in a situation like that, talk to your teacher, get some help. Nobody should live in that situation. And you don't have to. There's ways to get help. Other questions? Okay. Thank you very much. I appreciate the time and the opportunity to be here.